right. Why don't we get started here? Things are slowing down a little bit. I expect we'll get quite a few other people joining us as we get started here, but we've got a lot of ground to cover. So why don't we get started? First off, I wanted to welcome everyone to today's panel on the Copyright Claims Board. I am Keith Cooperschmidt, the CEO of the Copyright Alliance, and I will be moderating today's session. Today, with the help of some really terrific panelists, we're going to address a number of important issues and questions relating to the Small Claims Court, which is called the Copyright Claims Board, or the CCB for short. You'll hear us referencing it as the CCB. During our panel discussion, we hope to provide you, the attendees, with the information that you'll need to know to bring cases or defend cases before the CCB. And what we'll do to do that, we'll start the panel discussion by touching on the most significant features of the CCB. Then the panel will walk attendees through each step of the CCB process, first beginning with the filing of a case, and then we'll touch on the respondent's decision whether to opt out or not, and you'll understand what we mean by that a little bit later. After that, we'll discuss what takes place during an active proceeding, and then, of course, the final decision itself by the CCB. Then anything else doesn't fit squarely or neatly into one of those categories, we will cover in sort of a potluck section section at the very end of the panel discussion. And then if we have time permitting, we'll have a Q&A session at the very end. I want to note that we just found out that the last batch of final rules are set to be issued by the Copyright Office tomorrow. And so as a result, I'll kind of leave it up to our panelists how much detail they want to go and get into with these new rules. But hopefully we can provide you with some information that will be sort of official as of tomorrow. And before we begin the discussion, I want to make sure I thank our three sponsors, the Texas Accountants and Lawyers for the Arts, the American Society of Media Photographers, or ASMP, and of course my organization, the Copyright Alliance. And I also want to thank all the attendees for joining. If you have any questions for the panelists while you're listening today, please put them in the chat section, which you'll find at the very bottom of the screen. And then if we have time at the end, we'll hopefully have a chance to take a few questions that come up. So with that, let me kick things off by introducing our esteemed panelists and asking them to say a little bit about themselves. First, we'll start with David Carson. David is the Copyright Claims Officer at the U.S. Copyright Office. David, why don't you tell us a little bit about your background and also what a CCB officer does?
Thanks, Keith. Well, I've been practicing copyright law for over 40 years, hard to believe, but not enough to let me call myself an expert, but I can at least call myself a specialist. Started out as a copyright litigator, first in LA and then in New York for about 15 years. Then I came to the Copyright Office as general counsel in 1997, stayed there for 15 years. Spent a couple years in London working for the recording industry, and then came back to government, where I spent 7 years as the head of the copyright policy team at the Patent and Trademark Office, and then returned to the Copyright Office last summer as the first member of the Copyright Claims Board, and I've been joined by two others, Brad Newberg and Monica McCabe. Copyright claims officers are the people who preside over proceedings that are filed in the Copyright Claims Board. Small copyright claims. You'll hear more about that, so I'm not going to talk any more about what they consist of. You'll hear plenty about that for the rest of this meeting. So we're the people sort of the final decision makers. We've had a lot to do with the construction of the rules and so on, and we're assisted by a very able team, one of whom is here with us, and you'll meet her in a moment.
All right, that's a perfect segue for me to introduce Whitney Lewandowski, who is the Supervisory Copyright Claims Attorney. So Whitney, maybe you can also tell us a little bit about your background and also what a CCB attorney does.
Absolutely. Thank you so much for inviting us this afternoon, Keith, and thank you to our co-hosts, ASMP and TALA. I will just say I come from a background of public information and education about copyright law. I've kind of traditionally found my job to be talking about copyright law to anyone, anywhere, whoever wants to hear it. And that means I've had a lot of experience talking to people with a lot of copyright experience and very little copyright experience, people who are just coming to the subject matter. And so I joined the Copyright Claims Board because I see that as a continuation, see the board as a continuation of my work to help people know about copyright law and how to resolve copyright disputes. So I serve as the supervisory copyright claims attorney. I have two colleagues, Maya Burchett and Dan Booth. They are both copyright claims attorneys, and we are your first line of response of information. So we are going to talk a lot about the resources that the CCB has for participants, but know that there are also people, the copyright claims attorneys, who will play a role throughout the proceeding to help people understand copyright law and making the best case before the CCB.
All right, thank you very much, Whitney. As you can tell already, we have an all-star team here. So let me introduce the rest of the all-stars here. Tom Madry. Tom is the General Counsel and Head of National Content and Education for ASMP. Tom, why don't you tell us about your background and also about ASMP?
Yeah, thank you, Keith. And let me say just how excited I am to have David and Whitney here, as well as yourself and Terica. ASMP has been around since 1944 and is one of the largest and oldest commercial photography trade associations in the world. We focus on advocacy efforts, both judicially and in Congress, but our main focus is to help the smallest of small creators, whether they're photographers, filmmakers, videographers, any kind of content creator, understand copyright, understand the business of the creative fields. And I'm certainly proud to be part of ASMP. I also am very honored to sit on the board of TALA, the Texas Accountants and Lawyers for the Arts. I'm here in Dallas, Texas, and TALA was formed in 1979 to provide pro bono legal services, both in the legal world and in the accounting world, to the arts. And so we work with a lot of performing arts groups and visual arts groups and creators of all types, all of whom are very excited about the CCB, as ASMP is. This has been a legislative and advocacy priority for ASMP for probably close to a decade. And when it was signed into law, the CASE Act was signed into law, and we got the ball rolling here. It was one of the biggest victories for the smallest of creators. And I'm so proud to be on this panel and with this group.
All right, thanks, Tom. And our final panelist is Terica Carrington. Terica is the Vice President of Legal Policy and Copyright Counsel here at the Copyright Alliance. Terica, if you wouldn't mind giving us a little background and about yourself and about the Copyright Alliance, and then maybe if you can say a few words about what the CCB is and why it was created. I mean, Tom touched on that a little bit. Maybe you have a little bit to add.
Yeah, thanks, Keith. So just first of all, I just want to thank everyone for joining us, all of our attendees, and also thank you to all the sponsors for having us as panelists here to talk about the Copyright Claims Board. I know it's something that we're all very excited about. As Keith mentioned, I am VP of Legal Policy at the Copyright Alliance, which is an advocacy organization that advocates for the rights of creators all across the spectrum of copyright. So pretty much any kind of creator that you can think of, you can find within our membership. And personally, over the last several years, working on advocacy related to getting the CASE Act passed has been a big part of my job at the Copyright Alliance. And of course, more recently, we've kind of switched gears now that the CASE Act has passed to helping our individual creator members in particular become prepared for and understand, be educated about the Copyright Claims Board itself. So, before we get into a bit more of a deep dive about what to expect, I'll just give a quick overview of the Copyright Claims Board, or the CCB, as we'll be referring to it throughout today's program. But this is a small claims alternative that was created to be an alternative to federal court for certain types of copyright claims. In federal court, it can cost around $500,000 to litigate a copyright infringement case from start to finish, which is far too expensive for most individuals and small businesses. So the CCB was created to be an affordable alternative to federal court to provide much needed access to justice. And so we'll get into some more details about what exactly that means, but I thought that would be just a nice overview to get started. And with that, I'll turn things back over to Keith.
All right, thanks, Terica. So as we said, we're going to do this thing step by step, talk about filing a case all the way to the decision. Before we do that, though, before we do this deep dive, I'm going to ask the panelists to look at things more broadly at the CCB, right? So I'd like each of our panelists to name one key feature you think is worth highlighting about the CCB. I'm going to ask David, why don't you go first, if you don't mind? Oh, we can't. David, you're on mute.
I was on mute, very sorry. One key feature of the CCB is that our process is relatively simple and streamlined. I say relatively because we're comparing it to a court. We certainly had plenty of people commenting on our proposed rules that they were incredibly complicated, and we tried to simplify them, but there are rules because you have to have rules. So we'll operate more or less like a court, but with much less process, and in a way that's perhaps halfway between what your experience in most courts would be and what your experience in a local small claims court would be. Basically, everything's done online. Like courts, we have discovery, which is a process in which the parties exchange information about the facts relating to the case. In federal court, it's probably the most time-consuming and expensive part of litigation in the United States, but it's quite limited before the board. Testimony will be presented in writing, and we may or may not have a hearing. We'll then issue a decision, which will explain who won the case, and if the claimant won, how much the respondent will have to pay the claimant, assuming there is a monetary award. And it'll explain the reasons for our ruling. And that's it in a nutshell.
Okay, great. Who wants to go next here?
Well, I'll jump in and talk about one of the great features of the CCB is that it's inexpensive. And by being inexpensive, it's accessible to small creators, individual creators. You know, even though the CCB offices are at the U.S. Copyright Office, as David just said, you do not have to travel there. You can participate electronically and remotely wherever you are. That's a great benefit. You know, another thing that we fought for at ASMP was something that was implemented on the filing fees, and that this two-tiered pricing system. The filing fees are so much lower, and you have the ability to not pay the even low amount all at once with this two-tiered system. And then finally, as Terica was saying, you know, when you bring a copyright infringement case in federal court, it can be up to $500,000. The inexpensive nature of this, the way the CCB is designed to allow individuals to bring these matters is really a victory. It's one of the best parts in our opinion.
And I'll just chime in next. You know, as David and Terica outlined, federal litigation can be complex and time-consuming process. To navigate the system, you know, people often turn to attorneys. So what I'm really excited by is the CCB's ability and structure for goal towards accessibility, so that you can go through a CCB proceeding without an attorney. You know, with attorneys in federal litigation, they need to make specific legal arguments, provide strategy, and it adds to the overall expense. When we were developing procedures, we focused on establishing a process that can be navigated by non-lawyers. And we want to provide a variety of resources to help participants make their best case before the CCB. And now we do recognize that participants may still want to seek legal counsel or advice on particular matters with the CCB. And the statute gives us the authorization for supervised law students to represent participants in CCB proceedings. So one thing that we are working on to make the CCB broadly accessible is a directory of legal clinics and pro bono organizations that are available to take CCB clients. So we are working on building that right now, and we're really excited to provide that resource to people as we roll out.
And so I'll go ahead and jump in with one other thing that I think is important just to kind of highlight at the outset, which is that the process is entirely voluntary. And what I mean by that is not only is it voluntary in the sense that a claimant has the ability to decide whether or not they want to go to federal court or they want to go to the CCB. So even if they have a claim that is small enough to bring to the CCB, they still have the option to bring that case to federal court if they can afford to do so. So it's voluntary from the perspective of the claimant, but it's also voluntary for the respondent. And the respondent is similar to like a defendant in federal court. And so the respondent has the ability to decide whether or not they want to participate in a claim that's brought against them, and they can choose to opt out if they don't want to participate. And, you know, a lot of people wonder, you know, well, why is that the case? Why is it voluntary? Why is it not required like federal court? And the reason for that is it goes back to the Constitution. There are constitutional requirements that have to be met. People have a right to be able to have their copyright claims heard in an Article 3 court, which is a federal court. They have the right to be able to have a jury trial. And so in order to have your case heard before the CCB, the respondent actually has to waive those rights. And so for that reason, it actually does have to be voluntary in order to comply with the requirements of the Constitution.
All right, thank you, Terica. So one thing, I'm going to take a little moderator's prerogative here. I'm going to add to everything. This is a small claims court after all, right? So one of the things, the highlights for me is the remedies, is that there are damage caps to make sure it is sort of a small claims court. So that damages could not exceed $30,000 in total damages for a case that you bring before the CCB, or $15,000 limit in statutory damages for one claim. So there are monetary limitations that you should be aware of if you're thinking about filing a claim. And the other thing is that there are no injunctions. If you go to federal court, you might be able to get an injunction, in other words, to get somebody to stop what they're doing, basically. There's sort of something we'll talk about later, similar to an injunction, but there are no formal injunctions. So, okay, so let's move on to kind of our first step in the process, which is filing a case. Before we do that, we're going to do that with each kind of big chunk of the CCB we take on. There's certain terms that you're going to need to know, some of which we've already kind of mentioned in our overview here. But we want to make sure everyone, we don't want to lose anyone. We want to make sure everyone's on the same page here and to make sure everyone understands the terms that we're using. So I'm going to call on Tom at first here in sort of like a speed dating type approach to ask him to explain very quickly some of these terms. So Tom, first, let's discuss how we refer to the parties in a CCB case. So who is a claimant, who is a respondent, who is a counterclaimant?
Absolutely. So the text and the rules and the law have definitions for all of these people, but let's just break it down to who they are. The claimant is the person who initiates the proceedings in front of the CCB, and the respondent is the person against whom the proceedings are brought. Right now, there are certain types of claims that the claimant can bring, and I think we'll talk about what those are a little bit later. But you can imagine that if you are the creator bringing a claim of copyright infringement, then you would serve the respondent. The respondent can, in their response, become a counterclaimant, and at that point, they then have received the information of the claim and they are going to make a permissible counterclaim. Now, when I say things like permissible, all of these things are going to be outlined in the materials, both put out by the Copyright Office and Copyright Alliance and ASMP, a little plug in there. The one other subject I wanted to broach here is the statute of limitations. So in general, in copyright law in general, you have 3 years after the claim accrues, and that's the time period to bring your claim in front of the Copyright Claims Board. Now, there is a section in the law about tolling, which is tolling means stopping the clock on the statute of limitations claim during the period that the claim is in front of the Copyright Claims Board. There's some rules about that that we probably won't get to go into today. But when we talk about statute of limitations, I want you to really be thinking about that 3-year time frame from when the claim accrues.
All right, thanks, Tom. David, back to you. Let's talk about the type of claims that can be brought before the CC, but also what type of claims cannot be brought before the CCB. Oh, I think you're on mute again.
Sorry, 3 types of claims can come before the board. First of all, a claim for copyright infringement. That's a pretty simple one to understand, I think. Second, a claim seeking a declaration that you have not infringed a copyright. So if Keith is about to release a book and Terica has asserted that that book infringes her copyright, Keith, who might be a little bit worried about releasing that book in the face of an infringement for copyright, can come to us and ask for us to rule that no, he did not infringe it. And there are all sorts of circumstances where that might actually be a very useful tool for someone who's been accused of copyright. So one thing I want to make clear is the CCB is not just for copyright owners. It's not just for people who have a claim of infringement. It's for everyone. And we hope we find people coming from all sides of the issues to get rulings from us. Finally, you can get a claim for misrepresentation in a takedown notice or counter notification under the DMCA. Some of you may not know what that is, and it's sort of a detailed thing, but basically, you can send a takedown notice to certain online platforms like YouTube or Facebook who have posted material, or who rather are making available material that's been posted by their users. And if you send a takedown notice, their law gives them all sorts of incentives to take it down. On the other hand, the person who posted it may not agree and may send them a counter notification, and the law gives them all sorts of incentives then to put it back up. Because of that, the law also provides that if someone makes a representation in either one of those takedown notices or one of those counter notifications, then the person who was at the, not at the receiving end, but the person who suffered because of that, if you took my material, had my material taken down because you claimed it was infringing and it wasn't, and it was because I made you made misrepresentations, I might be able to get a claim for damages against you for the harm caused by that. That's a section 512F misrepresentation claim. Those are the 3 kinds of claims you can bring, and that's it. I mean, what can't you bring? Anything else.
No, that's exactly right. If you didn't hear David list those a claim, like if you have an ownership dispute, for instance, that wasn't on the list that David mentioned. You can't bring those type of claims before the CCB. So, and next question is either for David or Whitney, whoever wants to jump in. Are there limitations as to who can be sued by a claimant that potential claimants should be aware of? Maybe there's certain people they can't bring before the CCB?
Yes, the statute does have certain limitations. First, you can't sue the federal government. You can sue them in the Court of Federal Claims if that's where all claims against the federal government are brought. You can't sue a state, and as many of you know, it's pretty darn hard to sue a state in court as well. We're no better a forum for that, I'm afraid. You absolutely can't sue a state before the claims board. You can't sue someone who resides outside the United States unless they have sued you and you're asserting a counterclaim against them. So if someone from outside the United States asked for a declaration that they were not infringing your work, you could assert a counterclaim against them for infringement of that work. But as a general proposition, you can't sue someone from outside the United States. Then there are some other people who can't be sued under certain circumstances. Libraries and archives got a special provision in the Case Act, which says that a library or archive can submit a blanket opt-out, basically, and they've already started doing so. Basically, they file a piece of paper that says, I'm opting out of the Case Act, so don't bother suing me. I'm never going to come. I'm never going to show up, and I don't have to. That's in contrast to what anyone else would have to do, which is once you've been served with a claim, you can file an individual opt-out in that case. So if you're going to file a suit against a library or archives, please check the opt-out list, because if they're on it, then in most cases, you're not going to get very far. And finally, if you're suing an online platform like YouTube or Facebook, based on the fact that they're making available material that a user posted online, you can bring a claim against them, but only if you have already served them with a takedown notice and they've not complied with it, or a counter notification they haven't complied with it.
All right, thanks, David. And I want to point out before I go on, I noticed that Nora is from the Copyright Office is providing some very helpful kind of additional information, additional resources to supplement the responses of the panelists. So I encourage you to take a look at that in the chat as well while we're talking here. So thank you very much for doing that, Nora. Whitney, let's talk about the claim now. So someone wants to file a claim. What needs to be included in or with a claim that is filed with the CCB?
Yeah, absolutely. So a claim needs all the basic facts of the dispute that would allow a respondent to consider whether or not to participate or opt out. So we need to know, this is a general overview. I know Nora's going to drop in the chat all the details that you need to get your claim ready, but the type of claim that you're going to file. So what category that David mentioned applies to your dispute, who you are, who the respondents are, how to get in touch with everybody. We're going to be communicating back and forth. We need to make sure we have contact information. The fundamentals of the copyright protected work involved in the dispute. So that is what type of work is it? Is it registered or not? How many owners are there? Who's the claimant? and the where, the when, the how of the dispute, who took what action, where, what time, to the extent known. We know that, a lot of people are just kind of gathering information and they are in the best situation that they find themselves. We're not asking for perfection, but we do need to have the information sufficient that, we can have clear the claim. I'll talk about that in a moment. Clear the claim, have the claimant serve the respondent, and have the respondent be in a position that they can weigh whether or not they'd like to participate in the CCB proceeding. Oh, I will also mention, we do ask for claimants to provide what they want the CCB to do. So for an infringement or misrepresentation claim, that'll be awards, damages. For the non-infringement claim, a declaration that the use is non-infringing. We'll also ask for some important documents, things like the work, websites, communications. That's optional at the initiation of the claim point. We'll take care of that if the proceeding goes active, but know that that's something that you can get in place early on when you first file your claim.
All right, thank you, Whitney. I'm going to ask you a follow-up question here. So a claimant submits a claim to the CCB. The copyright claims attorney, like yourself, needs to review and approve that claim. What does that process entail? What happens if the claimant doesn't get it right the first time? Do they have a chance to fix it?
Yeah,
if they
absolutely.
don't get it right, and how many opportunities do they get?
Yeah, thank you. So yes, the copyright claims attorney reviews every claim that comes into the CCB for compliance. So what does compliance mean? Compliance means that the information that we have matches the requirements of the law, and it matches the requirements of our regulations, and that it makes a claim, essentially. Again, we're looking at how do we put the respondent in a position to determine whether or not to participate or opt out. If the claim is compliant, we clear it for service, and the claimant has the ability to go and serve the respondent. If it's not compliant, there are multiple opportunities for the claimant to go back and fix the issues that the copyright claims attorney has identified. The claimant has two chances, really. Each time the copyright claims attorney issues an order of non-compliance, identifying the elements that need to be fixed, and there will be 30 days for the claimant to file an amended claim. So we got that first chance to fix it, comes back, we do another compliance review. If it's compliant, great, serve. If not, you get another chance. You get that other chance. Again, you get another order of non-compliance, elements that still need to be fixed. 30 days, get it back. The claimant said with the claimant. If it's compliant, great, serve. At that point, if it's not compliant, at that point, we take it to the copyright claims officers who review it, confirm that there's continuing non-compliance with the law and regulations, and then we have to dismiss the claim without prejudice. I'll note that when we say, you'll hear maybe terms saying without prejudice, with prejudice. Essentially, when something is dismissed without prejudice, it means that it may be refiled again before the CCB, but keep in mind, if you want to refile a claim that has been found non-compliant, you want to make sure that you get it square with the law and the regulations before trying again.
All right, thanks, Whitney. Terica, let's talk about registration, right? Copyright registration is always a big part of enforcing your copyright and a big part of the copyright system. So does the work that's at issue in the claim, does it need to be registered with the Copyright Office before the claimant files a claim? And what should the claimant do if they haven't registered yet and they want to file a claim?
Those are great questions. So in order to file a claim for copyright infringement specifically before the CCB, the claimant must first file a registration application with the Copyright Office for the works at issue. So you can only file a claim for infringement if you have a pending registration application on file with the Copyright Office, or the Copyright Office has already approved the registration application and granted a registration certificate. So if someone wants to bring an infringement claim but hasn't yet registered their work with the Copyright Office, they can go ahead and submit a registration application as soon as possible. And once they do that, they'll be able to file their claim with the CCB. Now, the caveat there is that the CCB judges will not be able to issue a final decision in the case until the registration is approved and a registration certificate has been granted. So if a claimant wants to speed that process up, they can pay to have their registration application expedited, and the office will do its best job to complete the review of the registration application within 10 business days. In order to expedite a registration application, the claimant needs to submit a request to the CCB and pay the filing fee, which is $50. But one important thing to keep in mind about this is that the claimant can only request an expedited registration after the claim becomes active. So in other words, they have to first give the respondent the full 60 days to opt out. If the respondent does not opt out, the case becomes active, and then the claimant can request the expedited registration.
All right, thanks, Terica. So Tom, I'm going to call on you to kind of segue us to the next section of next part of the CCB process. So the claim has been approved by the copyright claims attorney. Then what does the claimant do? Like, what's the next step? How does the claimant notify the respondent that, hey, I've got a claim against you, right? And presumably it's some type of notice. And so what are the elements of a proper notice to the respondent?
Yeah, so once it's been approved, once you're ready to notify the other side, the claim is compliant, you have 90 days to serve the claim. And you're going to hear that term service. And there's really two types of service that I want to discuss. One is with serving individuals, right? The rules that govern process of service can vary from state to state. This is another place where the CCB handbook and all the additional materials are going to be incredibly helpful for you to determine how to serve your claim once it's been confirmed and approved. The individuals are one matter, but there's business entities as well. And there's a few specific things that you do want to keep in mind if you're going to be serving your claim on business entities. There's a database that the CCB has created for designated service agents for businesses. Now, if you're familiar with DMCA rules and the kind of designated agents for that, this is a separate database, okay? And businesses can opt to put a particular person to be served in this database. Now, if the respondent, if the person you're serving the claim upon is a business and has put their information in that database, then you absolutely have to follow that instruction and send your claim to that person. Now, that can be done by mail, of course, but the designated service agent can also elect to accept claims by email, and that will be noted in the database that the CCB has. If they are not listed there, then you would proceed like you would with an individual, which is serving the claim by mail under the particular steps that are required in the state that is relevant. There's also a concept of waiver of service. And you can ask the respondent to waive service by using a form that the CCB is going to provide. And that means that they've agreed to receive the claim without having been served according to the formal rules. Now, importantly, it does not mean that they've waived their right to opt out, okay? This just means that they have waived formal service and are receiving the claim. The respondent can choose to waive service because doing so gives them an extra 30 days to respond to the claim after the proceeding has become active. All of this related to how the claimant serves the claim upon the respondent is going to be detailed in the materials that I think we're going to talk about a little bit later from the CCB.
All right, thanks, Tom. So let's talk about we filed the case now. We've kind of notified the respondent about the case. What does the respondent do? The respondent has a decision to make, right? Do they opt out or do they participate in the case? So first off, I guess for Whitney is how does the claimant know who to serve?
Sure. So the claimant is going to serve depending on who the respondent is. So there's a couple, it's like a kind of a bit of a decision tree that the claimant has to go through. As Tom mentioned, when we clear the claim for service, we're going to provide a packet of materials for the claimant to provide to the respondent. You kind of, again, you make that decision about service sort of when you file your claim by identifying who the claimant is. If the respondent is an individual, the claimant will generally serve that individual. If the respondent is a business, the claimant should first check that designated service agent directory. This directory, it provides that eligible businesses can designate an agent. When they designate an agent, that's the way that you have to serve. But there are advantages, right? A designated agent indicates that they can be served by mail and may also be served by email. That's an option. So a claimant who has a case against a respondent in the directory means that you will serve by mail or by optional email. And if the respondent is unknown, you have to take a step. If you don't know who your respondent is, your claim cannot go beyond compliance review. So if you don't know who your respondent is and the infringement involves online content, you might want to consider what's known as a 512H subpoena. This is a way to go to an online service provider to provide to get the identity of a potential infringer. Now, this is a process that is it's a bit involved. It involves the federal courts. We're going to have some set instructions available online to help claimants identify who the respondent is through this subpoena process. So really, we think of service as like a moment that happens when you have a process server or somebody, take these papers, deliver it to a respondent. But really, you're kind of thinking about service back when you file your claim and when you're considering who your respondent is, and you'll kind of give us some information related to serving your claim at that time.
Okay, thanks, Whitney. So I'm going to go back to Tom here to ask him if you're a respondent and you want to litigate the case. In other words, you don't want to opt out. What do you do?
Well, this one's pretty straightforward. If respondent doesn't opt out, then the case proceeds. If you don't opt out of the proceeding, the case becomes active, and the CCB will then provide you additional materials, including a scheduling order, which is going to set forth the next steps. So very straightforward. If you receive a claim and you don't wish to opt out, then you will. The proceeding is going to become active, and you're going to get more information, including that scheduling order.
All right, so then we're going to go to David. So what happens if the opposite is true? If the respondent wants to opt out, what does the respondent do? Can they just pick up the phone and call the copyright office and say, hey, opt me out, or maybe just send an email to the copyright office? Or is there a more formal procedure for opting out?
It's not quite that easy, but it's almost that easy. If you're served with initial notice of the claim, it will tell you about the CCB and how a proceeding works, and it will also tell you a little bit about the opt-out option, a little bit about the pros and cons, and most importantly, maybe not most importantly, but most importantly in response to this question, how you can opt out. There are two ways to do that. First of all, you can go online, which is the recommended way. The notice will tell you exactly how to do that. You just have to fill in some very basic information. You have to find your case name and number on a list that will pop up. You have to file some basic information about yourself. You have to provide a particular key code that is going to be included with your initial notice, just so that when someone goes in to opt out of a claim, we're actually sure it's actually them because they've got the key code and not everyone on Earth has it. You have to sign, which means really when you're doing it on a computer, you just have to type your name in on the signature line. That's a valid signature under the law. And you're done. You'll get an email confirmation almost instantaneously. That's why we recommend it. You can go on there online. You can do it right away. You'll get an instantaneous email response. Nothing could be easier. But you can also use a paper form that we're going to include with everything that's served on you. It asks for all the information that you're asked to do online. You simply fill that out, sign it, and send it back to us in the mail. That's all got to be done within the 90-day period. Which means you have to drop it in the mail or give it to like a FedEx or a carrier like that no later than 90 days after, and you're done. You'll get a confirmation by mail, I think, with a paper opt-out. Is that right, Whitney? I'm trying to remember now whether we ended up with that.
Confirmation is generally by email. We do have some provisions in place when we know that people have restricted access to technology. So we do try to provide the quickest confirmation, but we do also recognize when people come in with limited access to technology. And so we have procedures in place for that as well.
All right, great. So Tom, going back to you, what happens if a respondent opts out within the deadline? What happens if they do not opt out?
Yes, so if you opt out, then the CCB will dismiss the claim against you. But of course, very importantly, the claimant can still bring that claim in federal court. That's part of the incentive to stay with the program. In addition to the notification that you get from the claimant, the CCB will send a separate notification if you've not yet opted out to make sure that you've received a copy of the claim and know what the opt-out period is and the other information that was discussed. And so as we discussed earlier, what happens if a respondent does not opt out? Well, very simply, the claim becomes active, because at that point, to get to the point where the respondent has received the claim, it's already been confirmed by the CCA, the attorney over there at the Copyright Claims Board.
All right, so we've talked a lot about opting out, not opting out. Let's talk a little bit about the decision-making process. Terica, maybe you can help us out here. Why would someone decide to opt out, or maybe decide not to opt out? Like what factors might go into that decision?
Yeah, sure. So, I'll take the question of why might someone decide to opt out first, and then why might someone not opt out? So someone might decide to opt out, frankly, because, maybe they feel like the claim that's being brought against them is a frivolous claim and doesn't have any basis. Or alternatively, they could opt out for any reason. If they just don't want to participate in that particular case, they can choose to just opt out of that proceeding. But I think the question that many of the people in attendance today, and frankly, a lot of people that I've heard from that's the bigger question, is why would someone choose to participate in a process that's voluntary? Why would they not just opt out? I think the biggest reason why someone might choose to participate rather than opt out is because of the significant limited liability at the CCB as compared to federal court. So if someone, has a claim that's brought against them and they look into the circumstances and realize, hey, I actually did infringe this work, or, I didn't realize it at the time, but, I have violated that person's rights. The significance of limited liability at the CCB, which is maximum $30,000 compared to federal court where there are no limits at all. And then per claim of infringement, there's a $15,000 cap at the CCB compared to a federal court, which is $150,000. If you assess the facts of the situation and realize that you actually might be liable for what you're being accused of, it could make sense for you to actually choose to go before the CCB rather than take your chances of ending up in federal court. Not only is there limited liability, but the process is significantly simplified such that you can represent yourself, so you don't have to take on that additional cost of having to hire an attorney that you would likely need in federal court. We mentioned before that this process is entirely voluntary, both for the claimant and the respondent. And although it is very expensive to litigate a case in federal court, it doesn't mean that every person who has a claim and brings a claim to the CCB can't afford federal court. So again, because the process is so simplified, because there's such a cost savings, there likely will be people who choose to bring a case before the CCB who actually could afford to go to federal court, but due to the particular circumstances of this case, may choose to bring that case to the CCB. So just because you are a potential respondent who has a claim brought against you at the CCB doesn't mean that that person can't afford to go to federal court. And so I think it's important to kind of weigh out the claim that's being brought against you, weigh out your potential liability, and really think about the fact that this person could afford to go to federal court potentially. And if that is the case, you would be opening yourself up to significantly more liability than if you just go with the case in the CCB.
All right, thanks, Terica. So we've talked about filing a case. We've talked about what the respondent does when they know they find out that there's a case against them. We have even talked about what the real big part of this, right? Which is what happens when you have an active proceeding. That's really the biggest part of this. And we're going to dive into that now. But before we do, we've got these kind of, like I said, speed dating questions, because we want to make sure you understand when we use terms, we want to make sure you understand what terms we're using here. So I'm going to call on Whitney here to talk a little bit about discovery. What is discovery? And in the process of discovery, there are terms like interrogatories, request for admissions, request for production of documents, very kind of legalese terms, perhaps. Maybe you can explain what those are, because we're going to talk a little bit about those. So
yeah, absolutely. So just to kind of orient us, we've got the claim, compliance, service. Now we're at that active proceeding. And as Thomas mentioned, we're going to issue that scheduling order. And the scheduling order sets forth what we're going to see in the active proceedings phase. And we kind of think about it, we have discovery, we have conferences, we have written testimony, we might have a hearing and a determination. Those are kind of the big chunks. But let's focus on sort of one of the technical terms, discovery. So discovery is the process of sharing information between parties about the evidence involved in the proceedings. This information includes documents, images, objects, or responses to formal questions. We have certain things, elements of discovery within a proceeding that allows people to exchange information in a structured way. So know that when parties are in an active proceeding, we'll be giving standard forms, standard questions, standard requests to both of the parties to kind of take the mystery and some of the complexity out of this discovery or information sharing process. So just to highlight some of the technical terms that you might hear, there's interrogatories. These are formal questions that asks the other party about information related to their proceedings. This is the who, the what, where, when, and why of a particular proceeding. The second thing is a request for admission. This plays a big role in federal courts. This is asking the other side to admit a certain fact or point or position. In the CCB, this is very limited. We only allow them when the parties really need them. But the other big part, so we have interrogatories, which is a term that you'll hear when you're involved with a CCB proceeding. But then the request for production of documents. This is a standard list of asking the other side, hello, I need any document that you're going to rely on, ones that you find important to your case and ones that might be important to mine. Again, when we're thinking about these terms, you're not going to be alone. We are going to be giving you standard lists, standard explanations, and we're going to make sure that we have conferences at the beginning of this process to make sure that everyone understands some of these terms that I've just talked about.
Okay, thanks, Whitney. David, so let's say the window is passed, the respondent has not opted out. What happens next?
Well, what happens next is first the claimant has to pay the remainder of the filing fee. Thomas alluded to the fact that we have a two-tiered filing fee. That was something we did after we got a lot of pushback to our initial notice of proposed rulemaking. So the filing fee remains at $100, but it's just $40 upfront. If the respondent does not opt out, in other words, if you have an active proceeding, then you have to pay the balance of that $100 fee, the additional $60. So that's the next step. We don't go forward till we have the second installment, shall we say, on the filing fee. Once that happens, then all parties who have not yet registered for the ECCB, our Electronic Copyright Claims Board, our online filing system, will have to register, because almost all papers are filed and served through the ECCB. I mean, one of the wonderful things about the ECCB is, unlike in federal court where you have to serve papers on parties, although I guess maybe with PASTA that's not necessarily the case anymore, but in any event, everything basically is served by us. You file it with us, it gets served on the other parties. And once that happens, there will be a scheduling order issued, and I think Whitney mentioned that, and I think Tom maybe mentioned earlier as well, which will have deadlines for all the major steps in the case. And the first deadline is going to be for the respondent to file a response to the claim. We talked a lot about the claim. We've also got a response. For those of you who know what federal court works like, it's the same thing as the answer, just like the claim is the same thing as the complaint in federal court. So it's where you have a chance to admit or deny what the claimant alleges and to say why you think, if assuming you do think, and you probably do or you wouldn't be filing it, why you think the claimant shouldn't win, assert any defenses you may have and so forth.
Okay, so Terica, I'm going to have you pick up the ball from there. So after the scheduling order is issued, the respondent then has a chance to respond to the claim. How much time does the respondent have to file their response, and how might the respondent respond?
Yeah, so the deadline as far as when the response is due will actually be set by the scheduling order that will be issued by the CCB. So it's important to pay attention to the dates and deadlines that are articulated there. And as far as how might they respond, one way that they can respond is to assert different defenses to the claim that's being brought against them. So a respondent can raise any of the defenses available under the Copyright Act. So one of the most known of those defenses is fair use. They can bring a fair use defense or any other defense under the Copyright Act, as well as any other defense available under the law. So for example, they might raise a defense about the statute of limitations. I know Tom touched on that earlier. In addition, they can raise counterclaims in response to the claim that's brought against them. But the counterclaim must be related to the claim, the initial claim, in one of two ways. It must either be an infringement claim or a claim of misrepresentation under Section 512F and arise under the same event or set of circumstances that gave rise to the original claim. Or if the original claim is itself a copyright infringement claim, the respondent can bring a counterclaim related to some sort of contract or agreement pertaining to that infringement claim. So those are two of the ways that a respondent can respond to a claim against them.
Okay, thanks, Terica. So once the respondent responds, the claimant then has an opportunity, perhaps, to respond to any counterclaims by the respondent. So we're not going to get into too much detail there, but then we jump into discovery. And you already talked quite a bit about this, right? Discovery can be pretty elaborate and pretty complex in federal court, certainly. Can you discuss a little bit, maybe to touch, I don't know if there's anything else you want to touch upon that you haven't already, to discuss the discovery process at the CCB and how it differs from discovery in federal court? You've already touched a little bit upon this. Maybe there's something you want to add here.
Sure. So, I actually saw a question in the chat about depositions. And this is actually a good point to make about discovery between the federal court and the CCB, is that there are just some elements that's contained in the federal court that are complex, exhausting, and costly. That just won't be with the CCB. And one of the main things that we will not be having is depositions. So depositions, as I mentioned, requests for admissions are limited to cases where they're really needed. It's the same thing with expert witnesses. We are going to be weighing very carefully when parties ask for expert witnesses, weighing those requests very, very carefully. So when we're looking at discovery, and we're comparing it to federal court, we're looking at a little bit more of handholding and involvement from the CCB. So, federal court discovery is handled mainly by the parties outside of the view of the court. Handling the CCB discovery process, not just with the beginning conferences before the discovery period begins, but also with those standard sets of interrogatories and requests for production of documents, means that the process is not is much more circumscribed throughout the CCB proceeding. And I'll also note, we've talked about sort of the main track for a CCB proceeding, but the office will also provide a smaller claims track. So this is for what's sometimes known as microclaims. So for people with a certain level of damages, they can select a smaller claims proceeding, which is even more stripped down than a main small claims proceeding. And in a smaller claims proceeding, we're not even looking at sort of a standard discovery process. We're looking at an initial conference with the CCB officer, and the CCB officer really discusses with the parties what information is actually needed for each party to sort of make their case before the CCB. From that, the officer will provide further direction about discovery, but there it's really more narrowly tailoring discovery to just the elements that are needed for the proceeding. So that's really the big difference between federal courts and smaller claim and the CCB is that it's less complex, it is more standardized, and with the smaller claims proceeding, it even has the opportunity to be more narrowly tailored to the proceeding at hand.
All right, David, Whitney talked a lot about discovery and you touched upon and others touched upon the scheduling order, and there are deadlines in there, right? And so what happens if a party misses a deadline? Is the case dismissed? And for that matter, just aside from deadlines, can the case be dismissed for other reasons beyond just missing deadlines?
Yes. Well, those of you who have had the pleasure of being in federal court know that deadlines are very important, and you definitely don't want to miss a deadline. It can mean the end of the case for you, depending on what the deadline is and how you deal with it. But we have similar rules in the CCB, but I think they're a bit more forgiving. We recognize that probably most people before aren't going to have attorneys, that maybe their first encounter with the legal system. So this isn't a game of gotcha. We really want to make rulings on the merits and not because someone missed a deadline. So nevertheless, we have rules. And if you miss a deadline, the other party may ask, or we may decide on our own that this leads to what is called a default. A default is where you didn't do what you were supposed to do, and therefore the case may be dismissed. But it's not going to be instantaneously. We will send you a notice. We'll send you a follow-up notice. We'll do everything we can to get you back in the case. If you don't come back in, if you just ignore it, then we'll issue a proposed ruling. We'll ask, if you're the respondent, for example, we'll ask the claimant to sort of basically present their case, make their case for us, explain to us why they ought to win the case. We'll do a proposed, if we think it makes sense, if we think, yeah, they've made their case, we'll give the respondent one more chance to respond and say, hey, here it is. Last chance to tell us why they're wrong. If they don't do it, then we'll issue a default determination. If they do it, we'll give the claimant a chance to respond one more time, and we'll ultimately make our ruling. So there's plenty of process here. Some people might think too many process, but the basic notion is that we really do want to get to a merits ruling, and to a certain degree, we're going to bend over backwards to give you the chance to explain to us your side of the case. But don't test the system too much, or you may find that our patience is worn out. We basically allow people to miss a couple of deadlines and go through this process, and after that, all bets are off. Keith asked whether there are other ways in which we might dismiss a case. Well, there is something in the statute which is called dismissal for unsuitability. And unsuitability is defined in the statute as including any of the following, but it says including, so it's not limited to the following. The failure to join a necessary party, that's a doctrine I'm not going to try to explain to you right now, but basically there are certain people who in a case just have to be in the case or the case can't go forward. Second, the lack of an essential witness, evidence, or expert testimony. One example would be, we can't issue subpoenas. So if there's a witness out there whose testimony is absolutely crucial, we can't really figure out what happened without that witness. We may end up saying, and you can't get them to show up, we may end up saying, look, this case is not suitable for determination by us because there's this key witness out there. We can't get this person in front of us. This is going to have to go to federal court. That might be one scenario. Finally, the determination of a relevant issue of law or fact that could exceed either the number of proceedings we could reasonably administer or the subject matter competence of the CCB. Remains to be seen whether we're going to get so many claims that we have to start doing that, and it's hard to figure out how we'd actually figure out, all right, this one's in and that one's out, but at least that's in there to give us some wiggle room. And then again, unsuitability, as I said, it's a term that is not defined to its completion, so it may well be that in the course of a proceeding, we may find some other reason why a case just isn't suitable for us. I mean, to give you an example that'll never happen, if Oracle versus Google were filed before the Copyright Claims Board, I think we would have said at the very outset, unsuitable for us. There are some cases that just aren't suitable for the Claims Board, and I think everyone recognizes that.
All right, excellent point there. So let's move on to remedies and talk about remedies. Tom, maybe you can talk about what type of remedies are available. For instance, we talked about injunctions, the fact that injunctions aren't available. Maybe when does somebody choose? We have statutory damages and actual damages. When does somebody elect which type of damages to get? What about attorney's fees and other costs? Can you
Yeah.
talk a little bit about remedies?
Sure. So let's start with monetary relief, and as monetary relief. And as you've heard a few times, the limit for a proceeding is $30,000 in any one proceeding, no matter how many claims or copyrightable works are at issue. When we look at monetary damages, we look at the same types of damages in federal court, meaning we have actual damages and the respondent's profits, or statutory damages. Well, actual damages are obviously those that you can prove. The actual damages and profits are the amount that you can prove to the CCB. But statutory damages don't require that proof. Now, statutory damages have limitations, additional limitations in the CCB. And so even though the cap on any one proceeding is $30,000, the cap on statutory damages for work is $15,000. So realize that if you have more than a few works and you're seeking statutory damages, then you may run up against that $30,000 cap. And that brings up that idea that has been talked about a few times. Maybe some cases aren't designed either on either side for the CCB. If you find that there's so many works and they all you're seeking statutory damages on all those works, then those caps may come into play. If you don't have your works registered timely, the statutory damage caps actually go down to $15,000 per proceeding and $7,500 per work. So, even though we have these great provisions in there about registration, you really need to make sure you get those works registered timely under the current registration provisions that are in Section 412. Now, you mentioned infringements, Heath. Injunctions. And the CCB can't issue orders that require the infringer to stop infringing. There's an interesting provision that says that if the parties agree that one side is going to stop infringing, then that agreement can be reflected in the final determination. And that agreement, you could make that agreement with the other party without admitting wrongdoing at some point, and then that can be incorporated. Attorney's fees are the last piece, and ordinarily attorney's fees are not the claimant, the successful claimant or successful respondent are not reimbursed for the cost for participating in the proceeding or hiring an attorney. But the CCB does have discretion. If a party operates in bad faith or acts dishonestly or is misleading, then the CCB can order that party to pay the other party's reasonable costs and attorney's fees with a cap. So the cap on that, if you have an attorney, is $5,000 for those reasonable costs and fees. And obviously that's a cap, so it could be lower. But if you are not represented by an attorney, then that cap is at $2,500 for your reasonable costs. There's also a provision that allows the CCB in extraordinary circumstances, if there's a practice or pattern of bad faith activity, to increase those amounts. But I think the thing to be thinking of there is that ordinarily, absent any of those bad faith exceptions, the successful party is not reimbursed for the costs and attorney's fees. And again, I'll go back to the idea that this body was designed for individuals to be able to bring their claims without having to hire an attorney to pursue them.
All right, thanks, Tom. David, let me turn to you. So we've let's assume we've gone through this process and you've reached a decision, the CCB, not you in particular, although I guess with a micro claims case, it could be, it'd be only one officer involved. But so how do the CCB officers reach a decision in the case? Are your decisions precedential? How will the officers deal with questions that involve a circuit split? Like you have a circuit courts out in California have one view and maybe the ones in New York have a different view or something like that. How do you deal with all that?
Well, first of all, we review the evidence, including testimony from the parties and witnesses, the statements from the parties, documents that have been submitted. If there's a hearing, what was said at the hearing. The first thing we have to do is figure out what the facts are. And we rely largely on the parties, almost entirely on the parties, to present those facts to us. We'll do our best to elicit the facts from them, but ultimately it's their job to do that. Once we figure out the facts, we got a pretty good handle on copyright law as it is, but we'll certainly do the research we need to do, and we'll listen to the arguments that the people make to us, and then we'll apply the facts to the law like any judge or group of judges do. Now, how do we reach a decision? We haven't had to yet. It'll be quite a few months before we have to, but we've got some experience working collaboratively ever since all three of us were on board as of last September, just in terms of making, recommendations on the regulations and so on. And I got to say, we're all strong-willed people who have our own views on things, and we've learned how to compromise. Which isn't to say we have lots of differences of opinion, but sometimes we do. And I think what we've been doing in the last several months is good practice for a three-person body that has to make decisions to sort of figure out how we're going to make decisions together. And we actually work together very well. So I'm very optimistic that you're not going to have a whole lot of dissents. You may not have any dissents. Who knows? I mean, the fact that two of us may go one way and one may go the other way doesn't necessarily mean there's going to be a dissent written. So we'll see about that. With respect to precedential value, some of you may not know, but we have what is called a common law legal system, which means that when a court makes a decision, that decision is it's sort of bound by that decision subsequently. When a higher court makes a decision, lower courts are bound by it from that time forward. The Case Act says specifically that our decisions are not precedential. They're clearly not precedential to anyone else. So, if you like a decision we make, you can try to cite it to another court, and the court may or may not pay attention to it, but they certainly don't have to. We don't even have to pay attention to it, but I've got to tell you that it's hard to think that we're not going to be paying attention to what we did last time around, next time around. If we got the same facts and we're applying the same law, chances are we're going to come up with the same result, just out of self-respect, we don't want to be going this way in one case and that way in another case with the same facts. But Keith, you did mention a particular provision in the statute, which says that we have to apply the law that would have been applied in the court in which the case could have been filed. Most of you probably don't know, the U.S. courts are divided up into 12 regional circuits around the country. Each circuit has a particular court of appeals. Those courts sort of lay down the law. So when there are questions of how you interpret the Copyright Act, it happens that different circuits have different rules on how to apply the law. A very notable one would have been one that was decided in the Fourth Estate case a few years ago. In some parts of the country, the registration requirement as a prerequisite to suit meant that the Copyright Office actually had to act on your registration before you could file. In other circuits, it just meant you had to have filed your application, and once you did that, you could go forward. The Supreme Court finally settled that and said, no, the Copyright Office has to have acted on your registration before you could go. But up until that time, in California, you could have filed right away. In Denver, you would have had to wait until after the Copyright Office ruled. There are other areas where courts are split on issues today, and we're going to have to look at the court in which the claim could have been brought and apply the law of that court. So we may have inconsistent decisions. Let's say this were a few years ago, and we had that registration rule. If we had a case coming that would have been filed in California, we'd rule differently than if we had a case that would have been filed in Colorado. So we have to do a little bit of jurisdictional analysis, a little bit of choice of law analysis. These are things that mean something to lawyers, probably don't mean something to any of you, but there will be times when we actually have to figure out where could this case have been filed? And if it's more than one case, we have to figure out, well, what's the case that has the most connection to this? What's the court that has the most connection to this case? And then apply the law as we understand it from that part of the country.
Okay, thanks, David. We're getting up against our deadline here, so I'm going to ask a few more questions, but ask folks, our panelists, to be a little brief if possible, so we can get through a couple questions and maybe respond to a question or two that we got from the attendees. So Tom, let's say a party gets a decision, but the losing party fails to comply with the decision, pay the damages or what have you. What can a party do to enforce the decision by the CCB?
Yeah, well, real simply, if the CCB orders a respondent to pay damages and they fail to do so, then the claimant can ask a federal district court to take action to require payment on the CCB final determination.
Okay. Terica, maybe you can talk very briefly about the safeguards that are in place to prevent abuse and bad actors. I know Tom kind of alluded to this a little bit, but maybe you can talk a little bit about that.
Yeah, sure. So I'll just start off by saying, I think everyone who is interested in the CCB small claims process is also equally interested in making sure that it's not a process that is being subject to abuse or misuse. So there are definitely safeguards in place. I think the biggest one is the fact that the process is entirely voluntary. So if for whatever reason you feel like a claim is being brought against you that is abusive or in bad faith, you can always choose to opt out of the process. In addition, I think, Tom touched on these, but there are some penalties for bad faith actors and bad faith claims, including potentially being subject to attorney's fees and costs, and also potentially being banned from bringing additional claims to the CCB for a period of 12 months. And then another safeguard that's in place is that the Copyright Office has the ability to limit the number of claims that can be brought by any one claimant. And then finally, I'll just touch on to prevent any kind of abuse in the notice service of process. The notice requirements for the CCB mirror the requirements for the federal rules for what has to be done to serve process in federal court. But there's also an additional notice that would be provided by the Copyright Office just to make sure that the respondent is aware of the claim against them and knows all the information that they need to know about their rights with regard to the CCB.
Thanks, Terica. So Whitney, sort of last question of the day here. We've covered a lot of ground. We've been flying through this, right? But hopefully people have, people have come along with us and they kind of understand a little bit better about how this all works. But there are a lot of other resources out there, right? Because we've talked a lot and people might be going, oh, I'm confused by this, or I need more information on this. So maybe you can suggest some places that people can go if they want additional resources or additional information about the things we talked about today, or maybe even things we didn't touch upon today about the CCB.
Yeah, absolutely. So throughout this presentation, my colleague Nora has been dropping in links from our website, ccb.gov. And this is sort of your first stop shop, whether you are a claimant or a respondent, to learn more about the CCB, the procedures, and the information that's needed to complete or participate in a CCB proceeding. This is going to be a growing resource. We launched last month, and we will be rolling out more and more guidelines, handouts, and we'll be showing off the handbook, which is going to be our, literal book in hand. If you are in the midst of a proceeding of the CCB, if you have a certain procedure, you can turn to the handbook and learn how to navigate. You can learn about the legal concepts related to that procedure. You can learn about what you need to do at a particular spot in a CCB proceeding. So we are going to be providing a wealth of resources. There was a question to hosts and panelists about choice of law, particularly as it regards to fair use. I'll just let you know the Copyright Office has a fair use index, which provides a summary of fair use cases across all of the circuits that David mentioned. And also, if you have a particular question, so you're going to ccb.gov, you're going to the handbook, you're reading the general information. If you have a specific question, you can always drop us a line at asktheboard@ccb.gov.
All right, thanks, Whitney. I will add a little bit to what you said. You can also, the Copyright Office got some amazing resources. We're trying to keep up, I guess, right? No, we have our own CCB alert that we alert people what's going on at the CCB that you can sign up for. We have a CCB guide that we've been working on. There's already one kind of edition that came out before the rules came out that you can find out. We're also having we have something called the Copyright Academy that you can access as well, to talk about sort of one-on-one interviews with all things copyright, but we're going to be having a lot more focusing just on the CCB. So we've kind of gone over a little bit, but if you don't mind, we got a lot of questions, and we will try to answer those on our website, and maybe maybe there may be answers on the Copyright Office website as well to some of these already. But I'm going to ask David if he can just briefly answer one of those questions, which is if a party is unhappy with the determination handed down by a CCB officers, is there anything they can do to appeal? I think that was one of the questions.
There are three things you can do. First of all, you can request that we reconsider our determination. You have to prove it. You have to persuade us that we made a clear error of law or fact that was material to the outcome. In other words, that we really blew it on the law or the facts, or that we made a technical mistake. If you still don't like where we are after that, you can request the Register of Copyrights, who's the head of the Copyright Office, to review our determination. You have to persuade her that we abused our discretion. Now, abuse of discretion, there are all sorts of ways you can describe it. I don't think I have time to get into it, but that's a fairly deferential standard as well. And finally, if you're still unhappy, you can go to a federal district court to seek review. The grounds for that are pretty narrow. Actually, the grounds for all forms of review of us are pretty narrow. They basically track what is in the Federal Arbitration Act. In other words, if you lose at an arbitration and you want to go to a federal court to get it overturned, the law says there are certain things you have to prove that are pretty deferential, because arbitration is considered a voluntary way that parties get together to determine a dispute. I think that's the philosophy behind the review of our decisions as well. You all agreed to be here, so you're going to have a pretty deferential standard, such as fraud, corruption, misrepresentation, or other misconduct, that we exceeded our authority or failed to render a determination. Those are the kinds of things you have to prove. So it's pretty narrow, but there are certain avenues you can take, which I would say would be only in cases where we really blew it.
Okay. And hopefully there aren't many of those cases, right, David?
Oh, never, never.
Never any case. All right, look, we've gone over our time here. I appreciate everyone's patience with us, and hopefully you've learned a lot. And I really want to thank everyone who hung in with us. If you asked a question and we weren't able to answer it, we will do our best to answer it on our website, the Copyright Alliance website. So I encourage you to go to our website and check it out. Give us a week or two to respond. But we'll do our best to try to respond to all the questions that came in here. And I want to thank each and every one of our panelists and our sponsors here, especially our panelists did just an amazing job as we flew through a lot of material, which was really tough. So hopefully everyone got a lot out of that. And hopefully we're very much looking forward to the CCB formally opening up its doors sometime in the very near future. And once again, thanks everyone for participating as attendees, as panelists, and also to our sponsors. Thanks again, everyone.
Thank you.
Thanks, Keith.
Thanks, everyone.